Constitutionally guaranteed judicial independence as a prerequisite of democracy. Comment. Judicial independence, a cornerstone of democracy. The statement constitutionally guaranteed judicial independence is a prerequisite of democracy holds strong merit. Here's why. Explained in points with examples. 1. Upholding the rule of law. An independent judiciary ensures all, including the government, are subject to the law. Example. In India, the judiciary struck down a government law deemed unconstitutional, protecting citizens' rights. 2. Protecting fundamental rights. Judges, free from external influence, can interpret the Constitution and laws, safeguarding individual rights. Example. The U.S. Supreme Court, in Brown v. Board of Education, used its independence to end racial segregation in schools. 3. Maintaining checks and balances. An independent judiciary acts as a check on the power of the executive and legislative branches, preventing any single entity from becoming too powerful. Example. In South Africa, the judiciary can review and overturn parliamentary decisions deemed unconstitutional. 4. Ensuring fair trials. Judicial independence fosters fair trials by guaranteeing judges impartiality and freedom from outside pressure. Example. International criminal tribunals, like the International Criminal Court, rely on independent judges to ensure fair trials for accused individuals. 5. Promoting public trust. When citizens believe the judiciary is independent, they are more likely to trust the legal system and its decisions. Example. Strong judicial independence in Norway contributes to its consistently high ranking in global corruption perception indices. It's important to note that guaranteeing independence is crucial. Without constitutional or legal safeguards, judicial decisions might be swayed by external pressures, undermining democratic principles. While challenges exist in maintaining complete independence, it remains a fundamental pillar of a well-functioning democracy. 2. Who are entitled to receive free legal aid. Assess the role of the National Legal Services Authority, NALSA, in rendering free legal aid in India. Who is entitled to free legal aid in India? Several categories of individuals are eligible for free legal aid in India, including members of scheduled castes, SCs, and scheduled tribes, STs. These communities historically face social and economic hardship and require legal support to navigate the justice system. Example. In Adivasi women seeking land rights protection, victims of human trafficking or bonded labor. These individuals are often vulnerable and require legal assistance to fight exploitation and seek justice. Example. A child rescued from trafficking needing legal representation in court. Women and children. They face unique vulnerabilities and require legal support in cases of domestic violence, child abuse, or other legal issues. Example. A woman seeking legal separation due to domestic violence, mentally ill or disabled persons. They may face difficulty understanding legal proceedings and require legal aid to ensure their rights are protected. Example. A person with intellectual disability needing legal assistance in property inheritance. Victims of disasters or emergencies. Individuals affected by natural disasters, riots, or other unforeseen situations might need legal aid to access compensation or navigate legal complexities. Example. Victims of a flood seeking legal assistance to claim insurance. Industrial workers. They are often involved in disputes related to wages, working conditions, or unfair labor practices, requiring legal representation to uphold their rights. Example. A factory worker injured in an accident seeking compensation from the employer. Individuals below a certain income limit. Each state has a specific income limit, but generally, individuals below this threshold qualify for free legal aid. Ensuring economic barriers don't prevent access to justice. Example. A farmer with limited income needing legal assistance in a land dispute. The role of NALSA in free legal aid. The National Legal Services Authority, NALSA, plays a crucial role in facilitating and overseeing the delivery of free legal aid across India, establishing a network. NALSA has established a nationwide network of legal services authorities at the national, state, and district levels, ensuring accessibility in various regions providing legal aid services. NALSA offers various services like legal advice, counseling, representation in courts and tribunals, and drafting legal documents, all free of cost to eligible individuals. Raising awareness. NALSA conducts legal awareness programs to educate people about their legal rights and the availability of free legal aid, empowering them to seek legal recourse. Monitoring and evaluation. NALSA monitors the implementation of legal aid programs and evaluates their effectiveness, ensuring efficient and equitable delivery of services. Example. A woman in a rural village facing domestic violence might not be aware of her legal rights or have the resources to hire a lawyer. NALSA's network can connect her with a legal aid lawyer who can advise her on available legal options, represent her in court, and help her seek justice free of charge. By establishing a robust legal aid system, NALSA strives to bridge the gap between legal rights and access to justice for marginalized communities and individuals in India. 3. The states in India seem reluctant to empower urban local bodies both functionally as well as financially. Comment. You're right. There is a perception that some states in India are hesitant to fully empower urban local bodies, ULBs, both functionally and financially. Here are some points highlighting this, along with examples. Functional reluctance, limited devolution of powers. Despite the 74th Constitutional Amendment Act listing 18 functions for ULBs, many states haven't fully devolved them, particularly in crucial areas like urban planning and public health. For instance, town planning remains under state control in many states, restricting ULB's influence over city development projects. Parallel bodies. The creation of parallel bodies like special purpose vehicles, SPVs, overseeing significant urban functions weakens ULB's role and significance. For example, the Bangalore Development Authority, BDA, in Karnataka handles crucial urban development projects, bypassing the Bengaluru Municipal Corporation. Financial reluctance. Inadequate financial devolution. ULBs often rely heavily on state grants, with limited independent revenue sources. This dependence hinders their ability to plan and implement projects effectively. For instance, a report by Niti Aayog states that only a portion of states have transferred recommended financial resources to ULBs. Delayed implementation of finance commissions. Only 18 states have established finance commissions, a constitutional mandate under Article 243, further hindering the financial autonomy of ULBs. This delays the process of determining fair resource allocation between state and local governments. These are just a few examples, and the extent of reluctance varies across different states. It's important to note that there are also states that have made significant progress in empowering ULBs, demonstrating the potential for positive change. 4. Compare and contrast the British and Indian approaches to parliamentary sovereignty. Differences in parliamentary sovereignty, Britain versus India. 1. Concept of sovereignty. Britain follows parliamentary supremacy, meaning Parliament is the ultimate legal authority. No law is above Parliament, and it can create or repeal any law it wishes. India follows constitutional sovereignty. The Constitution is the supreme law, and Parliament cannot enact laws that violate it. 2. Judicial review. Britain. Courts traditionally have limited power to review legislation for constitutionality due to parliamentary supremacy. This principle is changing, with Parliament incorporating human rights legislation and courts being more assertive. But the basic principle remains. India. The judiciary has the power of judicial review enshrined in the Constitution. Article 13. It can declare laws passed by Parliament or state legislatures unconstitutional if they violate fundamental rights or the basic structure of the Constitution, established in the case of Ananda Bharati case. 3. Written versus unwritten constitution. Britain has an uncodified constitution, meaning its constitution is derived from various sources like statutes, judicial precedents, and conventions. This makes it more flexible but also less clear and certain. India has a written constitution, a single comprehensive document outlining the framework of the government, fundamental rights, and procedures for lawmaking. This provides clarity and stability but can be less adaptable to changing circumstances. 4. Example. Britain. In 2011, Parliament passed the Fixed Term Parliaments Act, establishing a fixed 5-year term for Parliament. However, in 2017, Parliament passed another act to hold an early election, demonstrating its power to change its own rules. India. In 2013, Parliament passed the Right to Information Act, which promotes transparency and accountability in government. However, the Supreme Court struck down a few provisions of the act in 2015, highlighting its power to review legislation for conformity with the Constitution. These points illustrate the contrasting approaches to parliamentary sovereignty between Britain and India. While both have parliaments with significant legislative powers, the concept of ultimate legal authority and the role of the judiciary differ significantly. 5.